Hi, everyone. My name's Haley Hrymak. I'm a lawyer with Rise Women's Legal Center, and I'm joined today by Vicky Law, who is also a lawyer at Rise. I know a lot of you, so it's great to see familiar faces and excited to meet everyone who I haven't met yet. So today we're talking about creating safety in a broken system, and we're not giving legal advice, dun, dun, dun. So why do we call it a broken system? I feel like I'm really loud. Am I really loud? Is it too loud? Talk softly. Okay, so why do we call it a broken system? As many of you will know from your work, there's a big lack of understanding of violence against women within the family court system. Within our research in 2019 and 2020, it led us to publish that report you see on the screen, Why Can't Everyone Just Get Along?, where we really focused on what other research and many people have been saying for decades, that there is a huge lack of knowledge of family violence within the legal system, and this actually leads to it being more dangerous often when women are going through it. So as many of you know, intimate partner violence is so common. About 1 in 3 women experience intimate partner violence, and we know that about 50% of marriages end in divorce. So that means all the time, people experiencing violence are going through family legal systems of some kind. Often that's court, often it's out-of-court resolutions. We also know that when relationships end, that's the most dangerous time for people to be going through the court system or legal process of any kind. Because after the relationship ends, women are up to 6 times more likely to be killed by an ex-partner, and over half of all intimate violence occurs after the relationship has ended. So again, that's about the same time people are going through and getting divorced or working towards some kind of parenting plans or trying to get protection orders. So it's a very dangerous time. And one example of how we know that the legal system is not responsive to the pervasiveness of violence against women is that family law lawyers, for example, are not required to take any family violence education. So we've just talked about how this is the most dangerous time. This is the time where over half of all violence is occurring. It's really serious. And we're working with people who potentially don't have any education on family violence. So today, we're not going to really focus too much more on this about all the ways the system doesn't work for survivors of violence. But these are just considerations to share with clients before they attend the court, or we're going to talk about considerations to share with clients before they attend the courthouse and things to think about as they're navigating court processes, especially when they're experiencing court-related abuse. So we're going to talk about creating safety in the courthouse or creating safer options within the courthouse and coercive control in the court process. And Vicky's going to talk about remedies for litigation abuse. And together we'll talk about things for advocates to consider. I should mention that our slides haven't been posted to Shed, the online. I've never said that out loud. I've read it so many times. However that is said, but we have a 2-page handout that talks about the things we've talked about that maybe will be easier to flip through than the slides, and we'll post the slides. Okay, we will not post the slides. Just in. Okay. It's all you need. Great. So coercive control and litigation abuse. So litigation within family courts is often used by the abusive party to continue being in a position of power and to continue the abuse after the relationship has ended. And what is coercive control? So coercive control is an act or a pattern of acts or assault, threats, humiliation, and intimidation, or other abuse that is used to harm, punish, or frighten their victim. And the controlling behavior is designed to make a person dependent by isolating them from support, exploiting them, depriving them of independence, and regulating their everyday behavior. And Yeah, so many of you will have been working with people experiencing coercive control. It can present itself in many different ways. We'll talk about, for example, financial abuse. And so an abuser is often controlling the finances and controlling all the family money to try and control the behaviors of the other party. And that's, different from just normal behavior where maybe someone does all the taxes or controls the money in a way of managing kind of division of labor. But it's the way that an abuser does it is so the other party can't have agency or any financial autonomy. So this slide, on the one side, there's the coercive control examples. So this is kind of pulled from the definition of what coercive control is. And on the other side, it's how those can manifest within court processes. So I've just made this table, and there's many other examples that could fit in there, and there's different ways it could work together. But just to kind of go through, one of the ways that coercive controlling abusers act is by trying to humiliate the other person, degrading them and dehumanizing them. And then when you have that within a court process, some of the ways that that can look is by having false allegations. So writing an affidavit that's really humiliating for the other person, and it's not really relevant potentially, and it's just intended to degrade them or dehumanize them, and it has false allegations and things like that. Repetitive court applications, unnecessary court actions. And then another example of coercive control is the financial abuse. And when we see that in court processes, one of the ways that's often happening is people are refusing to give financial disclosure and having to go to court just to get this financial disclosure, which people are required to give. So withholding that financial disclosure and just making it so difficult to get that financial disclosure. Withholding child support. And there's lots of ways that people withhold child support, as you've probably seen in your work. Sometimes it's that they're just giving a little bit less than they're required to pay. And sometimes it's that they're giving it on a different dates, or sometimes they're maybe saying, well, I'm not going to pay for child support this month because I actually just bought the kids such and such. So that's my child support this month. So there's different ways. It's not always just non-payment. It's sometimes, happening in ways so that the other person isn't necessarily going to go to court and try and get that remedied. It's just so manipulative and kind of harder to address. Underreporting income. So for people who are self-employed, they're going to say they make $12,000 a year, but they absolutely do not. Making changes to intentionally avoid paying child support, paying support in other ways. And then threats and intimidation. And so oftentimes that's happening with pressure to settle and negotiate, and intimidating people by just filing like these massive court documents that then the other person must respond to. Oops. So we just released a research report, Creating Safety in BC Courts, and I'm just going to talk a little bit about that. We're really thankful that we were able to do this research with the funding from the Law Foundation of BC. And we focused on smaller communities because when we did that research a few years ago, we heard over and over again how it's really different going to court outside of Vancouver, for example. You go to these smaller courthouses and there's less space and there's lots of different considerations. So we wanted to focus on that. And the other thing we really wanted to focus on in smaller communities is that we actually know the incidence of violence is higher. So intimate partner violence is 1.7 times higher in rural areas compared to urban areas. And rates of police reported IPV are higher for rural women. And we know that already people are less likely to violence is underreported to the police. So those are some numbers that we went into the research knowing. And then we also know that there's a big impact on people's health when they're going through court systems everywhere. So we wanted to think about this research in a way of making people not have such negative negative experiences and such stressful experiences for their health. So participating in family legal systems often has significant health impacts, contributes to the development of PTSD. And this actually came out, or one of the reasons we wanted to look at this is when we did our past research, a lot of the women we talked to described having chronic health issues that they attributed not only to the violence, but to going through the family court process. And again, oftentimes these people are going through litigation harassment, so they're going to court all the time. So in smaller communities, one of the biggest issues of courthouses is there's a big lack of space. And so many of you maybe know this from your courthouse. Some of you maybe are in a bigger setting where there's multiple courtrooms and a waiting area, but some places the communities are using a place that isn't necessarily designated as a courthouse. So it's like maybe a community center that kind of doubles as a courthouse once every other month, that kind of thing. So it's not really, people are doing their best with the space they have, but it's not really set out to be a courthouse. And even the places that are kind of across the board, we heard that this lack of space is really the biggest challenge because people have to be right next to their abuser while they wait for their court process. And they can't, they often don't have a place to talk privately if they do have a lawyer. And so they're having these kind of awkward whispered conversations right in front of everybody. And they also know everybody there because it's a small area. And people described that as one of the hardest parts is just having total lack of privacy and having kind of this really personal matter before a community. So I'll just quickly go through this to say that we have some recommendations, and one of the things is trying to find ways without massive construction projects to make it so there is space that people can at least be separate from their abusers. So most of these courthouses don't have paging systems, so people won't know when their matter is being called, so they must stay in that space. But if there was, you know, those handheld pagers that you get when you go to a restaurant and you get it when your table's ready, something like that you can just give to people. It's very inexpensive. It's like $300 or something. We saw another courthouse in the States did this during COVID when they didn't want a bunch of people waiting in a small space. Somehow finding ways of having safe interview rooms and separate waiting rooms. Victim service workers often in some courthouses, in Smithers, for example, there's a room for victim service workers to be with the victim if there's a trial. And so that was a really positive thing for that we talked about. And if only there was something like that for family as well. So different things, ways of sharing space that already exists. In some courthouses, we heard that the courthouse library is often not being potentially utilized in the best way. Sometimes it's not open, and sometimes it's only accessible to lawyers. So we were just thinking, is there any way to make sort of interview rooms within it, or find ways of doing that? For places that don't have any room within them, finding some kind of parking lot trailer that can be nicely designed, soundproofed, 3 interview rooms type of thing. And then improving the experience of giving testimony using video. So those are just some ideas that I share with you as we kind of talk about all the issues, but that there's some really not that hard fixes. And then just interview room ideas. You could have, this is a picture I took of a breastfeeding pod in an airport. So something like that, soundproofed and maybe with a window, could be a place that clients can sit and meet their lawyers. And as you can see, these could be snuck into other spaces. So what does this mean for advocates is it possible before your clients are going to court to let them know about the space they're going to? So we are really used to the places that we frequent. And sometimes I think it's just really helpful to kind of break down what clients are going to walk into. Like, just so you know, there's only, so let folks know what to expect. They may have to wait a long time, as you all know, and the space may be limited. So is there any space you would recommend they wait? So for example, it's so simple, but in some cases, there is a courtroom and there's like a place outside. And some people think they must wait in that place outside of the courtroom and they shouldn't go into the courtroom until their matter's called. But that's not really true. And people just don't know that. So if their abuser is waiting outside the courtroom, you could let them know that they can just try and go into the courtroom. Maybe they'll be asked to leave, but probably not. And then they are at least separate. And let them know that there's those two places. And if they're waiting outside, that oftentimes sheriffs are letting people know it's time to come in now. So that's just something super small, but can mean they don't have to wait there all day. Some people said that they didn't know they could talk to duty counsel and that duty counsel just looked really busy, so they never asked them for help. So if you know where duty counsel is in your courthouse and what kind of things they can help people with, that's like a huge knowledge gap, because there's no one at the courthouse when people get there saying, you should go do this, and here's duty counsel, and they can help you with this. I mean, sometimes people get kind of directed there, but just if you can let them know, I know duty counsel is kind of always changing, but that's helpful. And then, will anything happen at court? Because sometimes people think I have a first appearance and I'm going to go and have my trial, because that's how the movies happen, and court proceedings are heard within the course of like 45 minutes. But as we, in the time of a TV show, but as you know, depending on what their matter is, you'll kind of have a guess of what types of things may happen, and just letting people know there probably won't, be a final order heard on this day. Today's really going to be about setting a date or different things. And let people know that they may not have their matter heard because, as you know, oftentimes, especially in smaller areas, court's only scheduled for 2 days, and criminal matters often take precedent over anything else. So if there's a criminal trial, even though you're supposed to be heard 9:30 on Monday, you're going to get bumped. All family matters are going to get bumped. And so it's really hard for people to plan ahead if they don't know that, because they reasonably believe that their matter will happen at 9:30 on Monday. And so just knowing that that might not happen, and to kind of plan their life around that, bring things to eat and drink and all of that, is just very helpful information for people who are going through this super stressful time and reasonably believe they'll be at court at 9:30 and probably home by noon, which isn't always the case. And really maybe nothing will happen. Like oftentimes things are adjourned to the next court time. And in smaller communities, if court's happening once every month, nothing may happen until the next month. So I think it's very important that people just know that. So letting people know there's often only one entrance and exit. This was a big thing within our research. People talked about feeling unsafe. Some survivors experience threats and intimidation at court and report feeling fearful of being harmed when they enter and exit the building. And we found that as well in our past research. Our survey, 42% of people indicated they had safety concerns in the courthouse, and 62% said they had safety concerns before and after court. So those are just things to think about, to talk about with clients. Risks following court, any kind of safety planning they can do with you, or talking about that. We are hopeful that there can be 2 entrances and exits that can be monitored, and having some kind of safe walk. So one client that we talked to, who was a court user who had experienced violence, said, having someone walk you out would be a great idea, so you can get in your car, at least you're in there and you're okay. I think that would have been wonderful, because then it would show the opposing party that somebody's watching. So things to think about in your work is let the clients know what to expect. So there's only one court entrance, for example, if that's the case in your community, and letting them know that, and maybe they want to arrive really early so that they can be the first ones in, and maybe they want to leave really late so they can be the first ones out, or things like that. And let folks know what to expect. So things about parking, maybe you have to park far or close, and any safety considerations around that. Again, it's really basic things, but this is what came out as these pieces that cause a lot of stress and potential safety concerns. When to arrive. And if there are safety concerns, you can absolutely, with your client, or direct your client to call the sheriffs ahead. So some places, the sheriffs will walk people to their car and will walk them back in. It's really dependent on the sheriff. Sometimes in those circuit courts, there's only one sheriff for the whole court day, and they must be in the courtroom. So that won't work. But you might be in a place where that's not the case. And I think they're technically not supposed to leave the court, but we hear all the time that they do to help people, which is amazing. And then ask about an option, any other things that the sheriffs can provide. So sheriffs, their whole job is keeping the court process and court safe. And so they are very good at that. And asking sheriffs when you call if there's anything else, if they can't do the safe walk, and any other safety measures. And oftentimes clients or people in our research talked about just having this feeling of relief because the sheriffs did know in advance, and the sheriffs kind of were there and were very clearly being helpful just by being present. And it was this sense of relief. So even just that phone call can make a difference. So one big piece, as you can appreciate, is court is so confusing and people don't know where to go. So one advocate said, I often see people at court like, what's going on? Nobody knows where they're supposed to go or what's supposed to be happening. There's nothing to indicate what you're supposed to be doing. So many people are navigating court with zero support. I know that many advocates who may sometimes have the ability to do court support just simply can't because you're short on staff and time and resources and all of the things that make it so you couldn't attend court. So people are going by themselves. And then the court registry is often the only, if the courthouse has a court registry, it's often the only place people can actually go for questions and to ask, because maybe there's no duty counsel and maybe there's just a registry in a courtroom and you can't ask the judge what. So the court registries are often kind of in this impossible situation of not really being able to help people, but also getting all of the questions. So we hope that there will be someone that can kind of help navigate. So during COVID, one amazing thing that we found is that because when you arrived at a courthouse, sheriffs were there to do the screening, or in many courthouses that happened, then people were met with a sheriff. They said, no, I don't have any symptoms. And they did all of that. And then then they could ask the sheriff, where am I supposed to go? And that was really helpful because normally people just walk into the courthouse and are kind of navigating what they're supposed to do. And they see a bunch of people waiting. So they go and sit there and that kind of thing. So hopefully also increased funding for court supports, clear signage, expanding the role of what advocates can do. And just a few things to think about. Is this a person you can go to court with? I know that you're all super busy and going above and beyond every day and what you have the ability to do for clients. And I've talked to a lot of people recently who've said it's kind of only gotten more workload and less support. So I'm not saying that you should be able to do things that are impossible. Just a consideration of, is it possible? Whenever possible. And then is there anyone else who can attend with them, even a friend, and asking them that, or and then of course, ideally, people would have lawyers to help them with the law. So if there was, has this person applied for legal aid? Is there counsel who could assist them? all of those things you're already doing, I know. So another big challenge is, of course, it's unpredictable. Like I've said, you could go to court at 9:30 on Monday, but actually you end up having court in like next July. So it's very hard to navigate that. And that's so stressful for people, obviously. And then there's a big issue with people actually getting to court, particularly in places that don't have any public transit. So people are hitchhiking to court. And then they go through all of this effort, expense, and labor, and they've gotten babysitting and they've taken time off work, and then their court matters adjourned to the next day, and they have to figure out a way to do it all over again. So very hard. And moving on to kind of talk a little bit about just what it's like to be in a courthouse. There's several. Kind of one issue is washrooms, so minimal to no access to gender neutral washrooms, no trans inclusive washroom signs. It's also possible that some courthouses do have these things. We just didn't really hear about that within who we talked to. Also, because space is so limited, sometimes washrooms are also doubling up as places for people to be interviewed, which is, just we can do better. Okay, so I'm going to talk a little bit about financial abuse. We've talked about how non-disclosure of financial documents, and this is really a controlling and oftentimes a tactic that abusers are using, because you can't get anywhere if you don't have the financial disclosure. So frustrating. So over $3.7 billion in child support is owed across Canada. In a Canadian analysis of child support orders registered with maintenance enforcement programs, 96 of the payers were fathers. So when we talk about this as a gendered issue, that's why. So child support, as you all know, is the right of the child, and the laws are all crafted in response to that, but there's still sort of lots of leeway given in terms of getting these orders, and people are trying to navigate that without lawyers and against an abusive partner. So many victims, out of fear of the batterer or abuser, are afraid to file for the child support that their children need. And in this one case, the judge said, I found that the claimant's failure to pay adequate interim support and his offer to pay more in support if the respondent would agree to relocate to Calgary was a further example of domineering and controlling behavior, and in the circumstances amounted to psychological and emotional abuse. So that's just a quote to support all of our work in trying to get people to be held accountable for paying for support. The problem, of course, is that it's so hard to get there. This is now a written judgment, holding people accountable, but oftentimes people without lawyers aren't going to get to that phase, and they're just going to not be able to go through it anymore of trying to get the disclosure. So with that, I'll hand it over to Vicky.
Okay, so I'm going to talk about how we can use the Family Law Act to get to this point where this case is talking about. I recognize the difficulties for our clients to actually even get to court, especially without a lawyer. So I'm talking about these sections as if the court and the legal system worked in an ideal world, recognizing that there are a gazillion barriers for clients. My goal is to give you the tools so you know what's in the legislation to help your clients. It's not a magic wand. It's not something that can fix everything. And we forgot to say that I'm hoping to leave 20 to 25 minutes at the very end for all questions or case scenarios if you want to have a discussion about that. And that's kind of why we're like flying through these really quickly. Okay, so enforcing financial disclosure. Everyone knows that you have to give a financial statement and there's required attachments, and there are rules that you need to do this before you get to court. The court does not really enforce this all the time, or 99% of the time, and oftentimes people do end up before a judge without any financial disclosure before them. I know that you all have your clients do a financial statement before they attend court, if you can, because that's the rules, and you want to make sure that your client is following the rules when the other side isn't. So what do you do when you've gone to court 2, 3, 4 times, telling the judge this person hasn't filed a financial statement over and over and over again? So you can use section 213. These are all in the takeaway, so don't feel like you have to scribble madly. Section 213 of the Family Law Act allows the court to make orders when someone fails to produce any type of disclosure, but financial disclosure is included in that. And what can the court do? So they can draw an adverse inference, meaning that, oh, this person didn't file their financial statement. I'm going to say you make X amount of dollars. So they impute income to that person. Does the court do that? No, but you can force them to because it's in the legislation. The court can also ask the person who didn't give the disclosure to give security to the court, pay the legal expenses of the client who provided this application. So if your client does have a lawyer and has paid for this lawyer to go to court to force this person to produce financial disclosure, the court can order essentially its costs that the opposing party has to pay. This doesn't have to be in Supreme Court. The provincial court can also follow the section to order the other side to pay the legal fees. Pay an amount of maximum $5,000 to the client, and they can also pay order the other side to pay a fine of $5,000. So there's like $10,000 maximum that you can ask the other side to pay. And I have not ever received a $5,000 fine, or I have asked for it. I always ask for it because the court will reduce it. The most I got was $1,000, but it was $1,000 more than what my client didn't have, right? So in this situation, I know people are like, well, the court's not going to order it. They might be really mad, so I'm just going to ask for $2,000. No, just ask for the $5,000. Imputing income. So you've got a client who doesn't know any type of information because, like Haley said, there's financial abuse. What do you do? How do you impute income? Work BC is very great. Work BC, if you type in, let's say, graphic designer, it will show you it's called the provincial annual median salary of a graphic designer. It will show you the highest dollar per hour they will make, a medium dollar per hour, and a low amount. And so you can use that to show to the court. It's a public document. So attach it to an affidavit, show it to the court and say, he says a graphic designer, he is not filing a financial statement. He says he makes $12,000. Well, look at here. Work BC says he actually makes $59,000 or $68,000. Can you impute income to him? So at least he pays a bit, some child support, right? That usually forces the other side to finally produce a financial statement, and then you got to go through a whole rigmarole with that. But something is better than nothing at this point. And it's not instant. It's not like snap your fingers. It's there. But you can use this. And we have actually used it in a number of our cases to show that the opposing party is lying about their income. Some clients are very savvy and they will take pictures of documents. So tax documents, pay stubs, bank statements. Even if you have one of those, you can make the calculation like ×2 per month and then ×12 for a year, and then you'll get an annual income, right? So you can use that, attach it as an affidavit and say, look, he's not providing his financial statement, but I've got something here. Let's just use this number because I don't have anything. We can't talk about litigation abuse without talking about frivolous and vexatious claims. And I can't talk about litigation abuse without mentioning Andrea's court-related abuse and harassment report. This was probably done 10 years ago, but it's still very relevant. I do have the link in your takeaway if anyone's interested in taking a read at it. It does say Andrea Volans, but it's the same Andrea. It's the same Andrea we know and love. So the quote that Andrea put in here is, some abusers intentionally misfile in the wrong court or use the courts closer to him instead of where the child lives. The jurisdictional court is the one in the city where the child resides. And so you've got opposing parties who have the money but won't get a lawyer because they want to file a gazillion applications in court. You've got an opposing party filing the same application, even though 2 months ago, the court just heard that issue. You've got an opposing party where they file the application, even though no circumstances have changed. So for example, they're filing an application to reduce child support, even though their income has not changed. That still forces your client to go to court no matter what, right? It's a waste of time. They've either got to take time off of work, so they're earning less money, or they need to find childcare, also less money. What do you do? This is another quote from Andrea's report. Say, the fatter the file, which means more court involvement, the more likely family violence was within. So that's probably true, because either the opposing party is filing documents to make the file larger, or the opposing party is not following court orders or agreements that requires your client to then file court applications to enforce the order or the agreement, right? So what do you do when you have an opposing party that files a gazillion things in court? So there's section 221 allows the court in both levels of court, so BC Supreme or provincial, to make an order that prohibits that party from filing any further applications to court without the court's leave. So that means you're asking the court to prohibit this person from filing any further applications unless they get permission from the court. That means that your client won't need to go to court unless the court says, yes, this is actually a legitimate application. We need to hear it and you can come now. So this can occur if the application filed by the opposing party is a trivial application, or if it's misusing a court process, or if it's otherwise acting in a way that frustrates or misuses a court process. So this is all under the section. It's in the Family Law Act that says this. The court can make this order for a specific period of time, so like 1 year, or they can say you're not allowed to file anything unless you do X. So I've gotten this order where OP hasn't filed a financial statement for a very, very, very long time. And the court said, you're not allowed to file any more applications unless you file a proper financial statement and you give all this disclosure and you include all these things in there. I've also seen an order where there is no time limit at all. Like they were just barred from filing an application without the court reviewing it. So if you want this type of application for your client, you're going to want to document the things that had prejudiced your client. So if they've missed work, if they've missed school, has their employer been mad? Have they been given a written warning that, you know, they might lose their job because they go to court too much, they're missing too much work? I had a client that actually did that, that had that happen to her. She was at risk of losing her employment. Does she need to find childcare? And you know, they're not paying the child support. They're not paying Section 7 expenses. So they're not contributing to that childcare expense, right? Other things would be helping your client document how many times they've been to court. So it's one thing to say, I've been to court so many times in the last 2 years, than saying, I've been to court 12 times in the last 2 years. That means this person has been to court every other month. And if you paint a picture like that for the judge and you write it out exactly what the other person has done, the judge is more likely to listen. Because I've gone to court so many times is so vague. What does that mean? Ignoring conduct orders. So the other person is doing something that's irritating your client. You go into court and you get a conduct order for them. So let's say they're not allowed to communicate except through text message, but they keep showing up to their house. They're not being abusive to the where there's like a safety concern, where it's not to the level of a protection order, but it's annoying to your client and your client doesn't like it. So there's a conduct order, they're not following it. To enforce a conduct order, it's section 228 in the Family Law Act. Also, the court can order to pay fines and also draw an adverse inference and make an order based on that adverse inference. So what that means is maybe it's not a protection order, but the judge says, well, you know what? You're not following my order. So I'm going to make an order that you can't go within 5 blocks of this person's house. Again, in an ideal world, this is not magic. In my ideal like justice system, what would be happening. Ignoring court orders generally. So this can be not paying child support, not following the parenting time schedule. You know, it says to do the exchange at 5 o'clock on a Saturday. They show up at 7 o'clock on a Saturday. Or just not returning the child at all. What do you do? Section 2, oh, it's not on the slide, but it's section 230. It's in the takeaway. It's section 230. Again, the court can ask the person to give security, pay fines, and pay the legal fees that the client incurred. Again, fines can be paid to the client and to the court, maximum of $5,000 each, so maximum $10,000. So I've talked about the section. How do you actually get it to court? In the provincial court, it's an application about enforcement. So Form 29, if you already have orders where the other side is not following, that's the application you use in the provincial court. In the Supreme Court, you use a notice of application with a supporting affidavit. In the affidavit, include the exhibits that your evidence needs. Always get legal advice first. Don't just go in asking the court to make an order to prohibit the other side from making a court application, because judges don't like it unless there's good grounds for it. The reason being, the court is supposed to be a public and open space for anyone to access justice. But this provision prohibiting the other party from making an application is supposed to protect frivolous and vexatious claims. So please get your client legal advice before you just go into court and asking the judge to make such an order. Help the client show the pattern of litigation abuse to the lawyer. So get your evidence in order, write out a calendar or a list of the court dates that the client had to go to because this person is not following the court rules. Show it to the lawyer, and that will help the lawyer decide whether or not there's enough grounds to make an application for this order. Also, a tip about evidence. So screenshots, there's text messages. People get a stream of text messages all the time. You all know to screenshot them. But I don't like to screenshot it with the word yesterday or 2 hours ago. Wait a few days until the actual date appears. So you kind of want it to say October 24th, 2022 at 4:44 p.m., right? Save emails. Ask client to diarize and journal the opposing party's behavior. This is a lot of work on your client. I recognize that. They're the ones who are experiencing the abuse. They're the ones who are experiencing the violence. Unfortunately, this system places the responsibility on them to produce the evidence. This tip about missing work. So if there are missing work, is there a difference in their income? Does it show on their pay stub that they're missing work? So then you can match the dates with the court dates, right? So pay stub usually 2 weeks. If it's significantly less, that means that, and you can show that there was a court date then you can just, connect the dots. Other forms of litigation abuse, scheduling extracurricular activities during the client's parenting time. I had one file where the opposing party scheduled something every day of my client's parenting time. They had 50-50, 1 week on, 1 week off, but he came to pick up the child for the extracurricular activity every single day after school. So that my client didn't have any parenting time. Not agreeing to medical care or counseling. That is another huge control tactic used by the opposing party, right? Because when a child needs a counselor, they need both parents or guardians to agree. And you've got one person that's not doing anything, ignoring the phone calls, ignoring the emails, et cetera, et cetera. So this is more difficult. It's more nuanced. There isn't a one size fits all solution because every family is different. You want to discuss with your client, what do they want the child to participate in? Like what extracurricular activities do they want the child to go to? Does a child even want to go to these many activities? Like I remember when I was 7 and 8 and I did not want to be hauled to swimming and skating and piano. And I was just like, leave me alone, mom. Can the client take the child to some of those activities? So let's say the opposing party takes them to soccer, but the child is also registered in basketball. Well, can the client take basketball and not go to soccer? Because opposing party here is saying, well, you can come if you want to, I'll just be there. And the client's like, I don't want to be there with you. Like, I just want to be there with my child, right? So that's another control tactic that we see often. This one is, I like to use this one, which is allocating section 41, so parental responsibilities, equally, but giving the last say to the client. Depending on who's on the other side, they might fight it really hard. But at least that gives the client the final say and have some form of control. And then before all that, I ask the client, what would you like in an ideal world? So I ask the magic wand question. If you had a magic wand, what would you change? And the first answer I get from my client is, I want him to change. I'm like, no. Sorry, that's not going to work. You can change everything else but him. You can control everything else but this person. So let's create something that is within your control. Do you want to pick up the children at school? So, he drops off Monday at 9 a.m. for school. You go pick up at 3 p.m. So you don't see each other, right? There's still proper exchange, but there is actually no interaction between the parties. Unfortunately, like I said, can't change the other person. And so when you leave agreements and orders very vague, an abusive person will use that to their advantage, and they will use that to control your clients. So for example, I am very much dislike the holiday time to be determined between the parties. Well, the parties can't determine anything. So especially holiday time where everyone wants the same day. Like, to me, it's really odd because you would think someone wants like the December 24th and then the other person wants 25th. No, every family always argues about the same day. And as I was writing this, I was like, no one's actually asked the kid if they want to be shuffled back and forth between like December 25th. Like I had one file where the suggestion was that the kid be exchanged at 9 a.m. on December 25th. And I'm like, really? You want the child to get up at 8 or 8:30 and then be driven over to the other parent's house at 9 a.m. on Christmas Day? Like, Christmas Day is supposed to be like in pajamas and, you know, eating chocolate. And that's what I did. But so be very clear and very specific in the terms that you're asking for. I've included a link to both the BC Provincial Court and the Supreme Court order pick list. That is a starting point. You can also use the divorce mate. The family law advocates have access to divorce mate. There's a separation agreement section there, and you can look through that and find terms. Just be very, very specific, and leave no room for interpretation. So unfortunately, the abuse won't end, but I think we can help. Talk to your client about ways that what they can do to be safe, because they've been keeping themselves safe all this time. Like you don't need to give them something new. You just need to give them the tools of family law system for them to understand what will make them safe. So some of the things that I've talked about are to my clients is she's like, oh, he's emailing me all the time and I get a ping all the time, an email from him. Well, why don't you create a new email account? Block him from your other one, create a new email account. Don't have notifications to go to your phone, and you can check it only when you want to. I mean, you have to check it regularly, like once every 2 days, but then you're not getting the surprise like bombshells. Like I talked about pickup at a school, there's also pickup at a public location. Do you have a Tim Hortons in your community or the public library that's open during the exchange hours? Yeah, I think that was it. Sorry, that was very an awkward end, but it won't end, but yes, eventually it will end, hopefully. It's okay. You know where to contact me. And that's Haley's information. We have more than half an hour for questions and discussion. So I am really interested to see if there's questions from the online audience, or if you're dealing with a really horrible litigation harassment case you want to talk about. But there's a hand there.
Hang on a second. Let me grab my.
So
Hello, thank you for your presentation. I was just curious, what has been your experience with police enforcement clauses?
I don't like them, because I don't think they're child-centered. But sometimes they're necessary. So I'm assuming you're talking about police enforcement for a parenting time schedule, and the parent is withholding the child, and then the police enforcement clause hopefully will prevent the withholding. Judges don't usually like them, because in their minds they're like, oh, there's going to be a cop car, and the cop is going to go and grab the child, put the child in the cop car, and then deliver it to the other parent. There are many ways a police enforcement clause can be implemented. And the reason why I say I don't like it is because I don't think the police are often trained to handle such a situation. I have seen officers who actually do a very good job, where they like arrive in plain clothes, there's no cop car in sight, and they talk to the parent who's withholding, and they say, if you don't follow this parenting order, we will take you. So they don't say we'll take the child, they're going to take the parent. And that's probably the best scenario that can happen. But I don't trust that all officers will do that. And that's why I don't like the police enforcement clause. Yeah, I think fines are a much better incentive, because you can, like, nobody wants to lose $1,000. If you put in, like, if you don't exchange a child, you are going to lose $1,000 or 2,000 or whatever. And that's what giving security to the court means, right? The person has to put that money into the court holds it for security. And if they don't follow the order, then the court takes that money. So I would rather go that route than the police enforcement clause.
Thank you.
Unless other people have had better experiences than me, but I'm going to bet that there isn't. Other questions?
Hi, my question, it kind of has two levels to it, because so often the clients that I'm working with have a legal aid lawyer, and I've seen legal aid contracts expire, and the client still may not have a support order because it, there wasn't disclosure and it wasn't pushed for. So I guess, like, it's hard. It's not that they didn't say to the lawyer again and again. You may hear that something like who has the dog when is dealt with before the support is dealt with. And I'm always kind of flabbergasted. How does this happen? So in my mind, I'm thinking that judges, I'm wondering, like, how responsive are they to the Section 213? Like, what's been your experience with that? Like, it seems like people can go to court numerous times without disclosure being given, and just continues that nothing happens to remedy that. Is it all on the lawyer? Should the judge be stepping in at some point? Like, what can we do as advocates? Because we're in this kind of position where we have to kind of tiptoe around the lawyer and not be too pushy. And so that just adds to the problem.
Yeah, it's a hard place to be in for advocates, definitely, because lawyers don't like being told they're wrong, and they don't like someone who's not a lawyer to tell them what to do. So I definitely recognize, like, the power imbalance there. That is one of the barriers that I've talked about at the beginning. My hope is, like, Rise, we are constantly training lawyers, and so my hope is that they will work better with advocates. But until we get there, there is a parenting time arrangement, whether it's formal or not, in any situation, right? As soon as the party separates, there is some form of arrangement. The court, I didn't put it in here because I didn't think I had the time to talk about it, but there are interim orders that the court can make for child support. And judges, more often than not, which is one thing I'll give them a credit for, is they don't like it when child support is not being paid. And you can ask for an interim order without prejudice, meaning that it's a temporary order and it's not going to go against the payor. It's not locked in. The court can always change it. If parenting time changes, like next week at the JCC or at the FMC, then child support would also change with that. The difficulty, I think, in that situation is not only do you have to ask for an interim order, you've got someone who hasn't filed a financial statement, so then you've got to provide evidence to impute income. But usually I have seen, even on like a list day, where the judge just forces the opposing party to say, what do you make? And impute income on that basis, because they don't like it when child support's not being paid. Oh yes, there's also two Supreme Court cases, which Colucci was 2021 and Michelle and Graydon was 2020.
Yes. I'm your backup.
Yes, I like having backup. So those two are the two Supreme Court cases that talks about payor, both were fathers, not paying child support for like the entirety of the child's life. And I think Agnes, who's doing the case law update, will probably talk about those two cases. Yeah. Oh, she talked about it last year. Yeah. So I would always just refer to those cases, and like a lot of family law lawyers aren't up to date on the case law. And so you might want to give them a nudge and being like, hey, read these two cases because like the Supreme Court really like tears down payors who don't pay.
Yeah.
Is there anything you want to add?
Just to say, like, those cases make our hearts flutter because they're really like, okay, for decades, people haven't been giving disclosure. And we are like here to say that that is so, so, so wrong, even though that's been said a million times. But they really are like this good thing. And like Vicky said, we aren't totally sure if those are being read all the time. So, but hopefully, like just in the past few years, there is like this case law that is more supportive of people, of payees. So that that conversation of like with lawyers could look like, oh, I was at this conference and I heard about these cases that say that it's really not tolerated anymore, that you can be on X hearing date and people haven't given financial disclosure. But I know it's very hard. So great question.
I also really like Colucci because it recognizes the gendered aspect of child support, and it does talk about the feminization of poverty. So
yeah, that session was it's online. It's on YouTube at Legal Aid BC.
And also if you just want to go on the Supreme Court website, they do case digests. So it's like instead of reading 90 pages of a case law, which I don't think I've fully read Colucci or Michelle yet, but it's like 2 pages. The case digest is 2 pages and it's like really easy to understand. Yes.
Hi, first of all, thanks. This is as a rural, small town, not even family law advocate, but just someone trying to help. It's very validating that these things are so complex. Have you, so not to get too specific, but when there is a opposing party who is continually either getting fired by or firing their lawyer and then delaying the process, so like they're not only not filing financial disclosures, but like not doing anything, is there a way to kind of navigate that with clients who are just like, you know, getting delayed because of all of that stuff?
I would go to the interim order route. So if it's like a parenting time issue or if it's a child support issue, just say, look, he can take all the time he wants, but these things need to happen and it's prejudicial to my client. So it's like whether she's not getting child support or she's not able to make decisions for the child because parental responsibilities is up in the air. Let's say the child has a medical issue and they can't agree, right? This is affecting the child. It's not in the child's best interest. So I would ask the court to make interim orders until he's ready to proceed. And then that way it might kind of bridge the gap.
Yeah. Is there on the new family court forms like a button to say this is for an interim order?
You know what? I don't know all 50 plus of them off the top of my head. So I'm going to do some research. And are you coming to the family court forms one later this afternoon?
I can.
If you want, you don't have to.
Okay.
I will have an answer for you after lunch.
Okay, thanks.
Can I just add to, so that's like to get support right now, but then what if he's just like never getting a lawyer? So in criminal court, so definitely happening in family court, like people don't get to just spend 5 years finding a lawyer. Like courts will have limits to that and say like, basically, if you don't come to court with a lawyer on this date, like that's it. So I don't know the total process, but there is limits. People can't just hire, fire. Like that's not.
Yeah. If it gets into like a really like cyclical problem, I would definitely show the court like the pattern of behavior. It's been so long that, you know, we need to set it down for trial. It needs to move forward. There needs to be a final decision.
I might just add a helpful word, if that's okay. The word peremptory. So if something is continually being adjourned, you can say, okay, can we adjourn one more time, but we're asking that the next hearing be peremptory, which means that something has to happen at that court date. Just
Yeah.
toss that word in there and see if it'll
Yeah.
see if it works.
This is all my steps.
There's a flip side to that too, though, because I've had clients lately who there's been a lot of like the legal aid lawyers are just so swamped that if a case is difficult, they're often dropping it. And judges have been really unreasonable in the amount of time they're giving people to get new lawyers. Like they'll say, they'll in 7 days, blah, blah. And it's like, are you kidding? Like they're going to probably have to wait 2 months just to get like a consultation with a lawyer. So,
that's when you step in. Like, that's when you could say to the judge, like, I'm a legal advocate in this community. Legal aid is currently taking X weeks to approve a client, and they are taking X weeks to find a lawyer. You could say, like, if there are lawyers conflicted out, you can say that the lawyers are conflicted out. We have to find someone out of community. Legal aid has to approve travel. Like, that's where your experience comes in. And I see a hand. Maggie has something to add to that.
One thing that you can do, and particularly in the circumstances that Vicky is describing, is you can apply to the court to be a Mackenzie friend. And Vicky, I'll give it back to you to talk about that. I just wanted to highlight that.
So I think the provincial court is a lot lax because they have actually let Sam Davis, who is the advocate at Rise, talk even without an application to be in Mackenzie friend. The judges in the provincial court are just like, yeah, you seem like you know what you're talking about, so just talk on behalf of the client. In Supreme Court, it's a little bit more formal. Both levels of courts have a notice, which I don't have the number off the top of my head right now, but like you follow the instructions to become a Mackenzie friend. And what a Mackenzie friend is, you're not a lawyer, but you're there to assist the court because you know the file and you know the client, and you can share information with the court that may assist them in making a decision, usually on procedural matters like this, right? So if the judge is like, I'll give you 7 days to find a lawyer, and you're like, actually, it's taking like 3 months to find a lawyer, like that is within your wheelhouse to say, because you're the one helping clients to get legal aid. You're the one who is trying to get them a lawyer.
And can I just add, like in a situation like that's going to come, but you can't go with the client to court, you can like give them all that information and they can let the court know and just see where that gets them. Because it's just, I know advocates can't always be there and making the in-person.
Yeah. I don't know if that will be successful. Like the judge might be like, oh, whatever, you're just making information up, which I have seen judges do. And so what Rise has done, unfortunately, is we've written letters on our letterhead, and we're like, we are the legal advocates at Rise Women's Legal Center. We assist clients with getting lawyers. We are currently in the process of helping this person get a lawyer. In our experience for the past X months, it has taken this long. And the client shows up to court. We send a copy of it to the opposing party and the opposing counsel if they have a lawyer, so that they're not blindsided by it. But we give a physical copy to the client so that they can hand up to the judge. If it's a virtual hearing, we ask the client to email it to the registry so that the judge has it accessible, hopefully.
Vicky, can you mention one more time what the website is for the case digest?
Oh, the Supreme Court website. I don't have the exact link, but if you go to the Supreme Court of Canada website, not BC, the Supreme Court of Canada is the one who decided that both the Colucci case and the Michelle and Graydon case, there's a case digest on their website for both of those cases. Are there any questions, other like case scenarios you want to talk about?
Sorry, I'm going to use the information while I have it. In terms of relocation, which I know is like very hard. Any kind of remedy you can think of where somebody who's left the community because of violence, who's being called back by the court, even if that person in my scenario, the opposing party doesn't even have any parenting time, but they just have supervised visits. Is there any remedy that a client can use to say, like, can't I just stay in the community that I feel safer in?
I'm going to say no. Without knowing more information,
Right.
I think it's best for your client to get legal advice, because it's so the session this afternoon that Haley, Brittany, and I are doing about filling out family court forms is actually on a fact pattern for relocation. So another nudge, you may want to come to that. But I am not going to talk about relocation case law, because we would be here for years. I don't even know if the courts themselves have it figured out. It is that problematic. And so when the question, I think a few of you asked for us to talk about relocation at this conference, and I said, the lawyers don't even know what they're doing. The courts don't even know what they're doing. This is just going to be incredibly confusing to like teach you the case law of relocation. But the bottom line is if a person is a guardian and they have a relationship with the child, an ongoing relationship, no matter what that looks like, they can't move without consent or a court order.
Yeah. I mean, it makes sense. It's just a bummer.
Yes,
Yeah.
absolutely. Your client will most likely have to go to trial. And there's a number of like minute nuance factors that need to be considered that we can't get into today, unfortunately.
All good.
Oh yeah. Maggie, not to put you on the spot, but does everyone know Maggie? She is, why don't you introduce yourself?
Sure. Hi, I'm Maggie. I am the, thank you. Thank you. I'm new to Rise. I'm the supervising lawyer. I'm just going to get right up here. Okay.
Yeah, do it.
The supervising lawyer of the centralized legal services, which is a new program. It's a pilot program that we're running to standardize the level of supervision that offered to family law advocates in the province, with a dedicated mentor lawyer to help advocates to be the best they can in the roles that they're doing in different communities. So currently I'm supervising 6 legal advocates in the province, and potentially that is changing, increasing soon.
Is there anything you want to add about litigation, abuse, or harassment?
I have a lot to say, and I'm going to shamelessly plug my session for tomorrow, which is high conflict co-parenting, where I'm going to be doing a deep dive into the different tools to put in your toolbox for when you're dealing with bad behavior from abusive partners in the co-parenting context. And of course, there is a little bit of overlap with what Vicky and Haley have talked about today, but we're going to be talking about conduct orders, protection orders, as well as vexatious litigants, peace bonds, exclusive occupancy orders, and one more thing.
Interim distribution?
No.
Oh.
No. It might be. I think it may be at 1:15 tomorrow. So yes, that's all.
Okay, thanks. Other questions?
Really frustrating, or maybe things that have worked really like well that you've navigated.
Yeah, if you've done something that worked amazingly that we didn't touch on, please share.
And like the bar doesn't have to be amazingly. It could just even be like less terrible.
Yeah.
We're interested in it all.
A little bit better than what the situation is right now.
Be fair with the bar that less terrible kind of is amazing.
Yeah. Yeah, when the Supreme Court of Canada released their most recent decision about relocation, Berenguet and Grubelinas, they spent 6 paragraphs on family violence, and I literally jumped in the air because I was so happy, and my partner was like, you got 6 paragraphs in a 90-page decision. And I was like, that's 6 more paragraphs than nothing. Because what was it before? Nothing. I don't remember what the 6 paragraphs are. Do you want to talk about
Just
that?
that they, or kind of to your question about relocation, like not a relocation presentation, but just to say that the Supreme Court of Canada talks about how, of course, family violence is a consideration in relocating, and courts must consider that within the relocation. And there's 6 paragraphs and they're really great. So our hearts fluttered again.
I think there's another question.
How do you navigate situations where an individual is still romantically attracted to or still the opposing party and may not want to go through certain routes that would benefit them and the children in the long term?
Yeah, so we can't force clients to do what we think is best, right? Clients know for themselves when they are ready. I have had a client who separated for a year before they were ready to file a notice of family claim. And we just got to be there. Give them the information, give them the tools, help them understand what will happen if they don't move forward and what will not happen. What will happen if they do move forward. Like, don't paint a pretty picture if they do move forward with going to court, right? Because court is not pretty. Unfortunately, it is the only system we have to deal with this. We can talk about like alternative dispute resolutions, mediation, arbitration, negotiation, whatever, but that doesn't work because you can't negotiate with an abuser. The majority of my clients, when they come to me, they say, I don't want to go to court. I'm very scared of going to court. I want to negotiate this. And I say, okay, let's talk about a time you tried to discuss something with your partner when you weren't separated. The two of you had opposite views. How did that work out for you? When I say that, their emotions completely change. And they're like, oh. And I said, we can go with mediation. I will be there, or you can be there as a support person for your client as an advocate. But that's not going to change the power dynamic between these two individuals, unfortunately. And I say, we can always go back to mediation. We can always negotiate. Like 90% of their family law cases negotiate and settle anyways. But my experience is if we start off with negotiation or we start off with a settlement, the other side doesn't come because they're not forced to come. They're not forced to come to the table and talk about the issues that are there. That doesn't really answer your question, though, about the person who isn't willing to move forward. And unfortunately, there's nothing you can really do to force them.
Yeah. And can I just add that there's lots of like bad science that has tried to explain violence for like the past decades. And I think just going to reiterate what Vicky said of like just being there for people, non-judgmental, recognizing, it's not about what we want people to do. And I think there's sometimes this leaning into trying to explain why this could be happening. And I just really encourage, like, that's not really helpful. And people are doing things for a variety of reasons. And so I'm just thinking of like the example of there's this cycle of violence and there's a honeymoon phase and all of that. And I don't really find that helpful. And I don't necessarily think it applies to different situations. So I just think exactly what Vicky said, and it's really hard, but trying to not fall into this like maybe potentially inaccurate explanations of violence and people's experiences, because everyone's experience is so unique.
Yeah, I think if we remember at the end of the day that like the clients know how to keep themselves safe, they know what to do. And if it doesn't work out, then there's always another option. Like court's definitely not perfect. So our role is to support clients where they are, and to give them the tools to get to where they want to go. I don't see myself as a driver, like even though I'm the lawyer, I'm taking my instructions. Well, I guess I am the driver. The client is telling me where to go, right? I'm just driving the car. If my client wants to tell me to go straight, run through the red light, that's illegal. I probably have to stop and have a conversation with my client. But I'm not going to be turning right because my client didn't tell me to turn right. Yeah.
Like you have this 2 years to change your mind on this, and then it's gone for these issues.
Yeah. There are clients, so many clients walk away from their entitlement because of an abuse. And I'm like, okay, but that's like $50,000 you're walking away from. Are you sure you don't want that? And they're like, yep, I don't, the $50,000 isn't worth the fight. And you just unfortunately have to see that happen because I can't force a client to go after the $50,000. Yes, put it in. Well, for the lawyers in the room, put it in writing, please. Like, make sure you explain to your client that there's $50,000 and they're not going after it. There's a question. Yes.
So your last comment about mediation, I have a client who the other party wants to do mediation, and
is that one microphone not working?
Hello.
Haley's coming.
So I have a client who the other party wants to do mediation. There's a history of abuse.
It's back.
Okay. So the other party wants to do mediation. There's a history of family violence. And so my client, of course, feels really uncomfortable doing mediation. She has a family law lawyer who's recommending that she do it because the lawyers say that the judge wants to see that they have tried working things out. So I don't know if you have any suggestions about like how to navigate this. She's agreed to at least talk to the mediator and figure out, what's going on. The lawyer has said that if she talks about the family violence, the mediator might be able to say this isn't going to be a good fit, but there's no guarantee that that's going to happen.
Check.
So, do you have any suggestions on that?
Yeah. Check.
I'm assuming that the virtual people didn't hear. Okay, so I'll just repeat very brief notes. And if I've got it wrong, you tell me. Client is in a situation where the opposing party wants to go into mediation. There's family violence in the situation. Client's lawyer is telling her to go forward with the mediation because it will look better before the judge, and maybe speak to the mediator about the violence. So then the mediator can decide whether or not to propose that we move forward, because maybe the mediator can say, no, this is not a situation where mediation is appropriate. Did I get that correct? Okay. So tips would be, find a mediator who understands family violence. I agree with this lawyer that if the client just flat out says no, then it would kind of look poorly between them, but by the judge. Unfortunately, that's just how it works. They're not supposed to. Like the judges aren't supposed to have that, have that judgment, but it's a unconscious bias probably, or maybe even conscious. So find a mediator who knows about family violence. B, you can talk to your client what mediation can look like, because they're now with Zoom, everyone knows how to use Zoom. There can be virtual mediation. There can be shuttle mediation, even if it's in person. talk about like safety planning. Like if there is going to be a mediation and it's going to be shuttle, can the client arrive half an hour early so they're not bumping into each other in the hallway, kind of like what Haley was talking about? Can you be the support person at the mediation? So if the lawyer misses something about violence or like a controlling behavior or a controlling tactic, you can be there to remind the lawyer, hey, this thing this person is doing, that's not okay. So unfortunately, I would have to say, based on what you've told me, I think the client should at least move forward and talk to a mediator. If they haven't chosen a mediator yet, what I usually like to do is to choose 3 mediators. Hopefully all 3 has some understanding of family violence, and let the opposing side choose one. That way, the client will end up with a mediator who understands violence.
And
Do you want to turn up here? Keep talking.
hello, test. Okay. And just one thing to add, that in Zoom mediation, some mediators are amenable to like figuring out what works best for everyone, and they could actually be in different breakout rooms. So the person may never actually have to see them. And then if the mediator doesn't agree to that and they end up going through it, they, some advocates talk about like putting a sticky over the other party's face. You still have to hear what they're saying, but it's just a little bit of a barrier. And then also, she may decide she just wants to try it. And then it doesn't mean it has to lead to minutes of settlement and an agreement. And they just end up in a similar place than they started, of just trying it, but depending on obviously what she wants to do.
Yeah, I think that's why, I think it's really important to have a support person there, because oftentimes I do see clients saying, well, I felt like I was back in the relationship where I had to compromise everything and give in to what they're asking for. But you can be there, even if your entire role that day is to remind them, you don't have to say yes. You don't have to say yes. Like, that can just be your role. And that's a very important role.
A question online.
Yeah.
How would this play out if the individual hasn't disclosed family violence? Most clients don't fill this out on the NOFC.
So it's not, it doesn't, you don't have to disclose family violence on the NOFC. There's actually, the only part that asks for family violence in the NOFC is if you're asking for a divorce due to cruelty, but it's not required. So it doesn't matter if you haven't disclosed it. Mediators and lawyers are required by the Family Law Act to screen for violence. Yes, some definitely do it better than others. But that's my hope, is that if you're supporting a client who has experienced family violence, please remind them to tell the mediator that there is family violence. I hope that answers the question. And I see there's a hand. Judy, yeah.
Back to the mediation thing, sometimes I have sort of shared with clients that it might be beneficial also, because just listen, pretty good idea of where that party and their lawyer are coming from. Mm-hmm. And maybe if things don't get resolved at that point, at least they have some sort of, they can develop a toolkit to deal with it going forward, because they'll know the perspective.
Yeah, that's a very good point. And sometimes, like, I just had a trial a few months ago where the judge was not great. And I decided to settle it because I knew that by settling it, it was much better than whatever the judge would give me. So if you do know who the judge is on the trial, if it's a good judge, great. Like, that might change your client's position. If it's someone who is like, you might be like, well, let's try this out, because at least the client has some form of control through a mediation. At a trial, the client has no control. Also, if the other side has a somewhat decent lawyer, that's the best case scenario, because that lawyer will not allow the opposing party to bully your client, hopefully. Oh, we'll do that one. And then over here.
Sorry
And oh, it's time. But yes, keep. I'm happy to stay.
Mediator / arbitrator. Can you talk about that role at all?
I don't know much about arbitration, but they are separate. Maggie, do you know? Yes.
So a mediator is somebody who helps you get to the middle. An arbitrator is somebody who listens to both sides and arbitrates, makes a decision like a judge. A arbitrator, oftentimes what happens is that the people who are mediators are also wearing an arbitrator hat if they're hired to do so. But you do have to be really careful and do your research and make sure that their credentials are more recent. You get some better arbitrators than others. But the way that it works in Supreme Court, anyways, I'm not sure about provincial. But if you agree to appointing a arbitrator, you can actually do something called a mediation arbitration, where you do the mediation. And then if you can't come to a conclusion, the mediator arbitrator puts their arbitrator hat on and they make a decision like a judge. So really the only difference is what that third party's power is, what their role is in that discussion. It often looks very similar, mediation and arbitration. But the end result, what that third party is going to do with that information is what's different. So
thank you.
Yeah,
just a note, mediation and arbitration is not cheap. Like parties do have to privately pay for it. However, Access Pro Bono does have the free family law mediation if you qualify. But no lawyers are allowed to be involved in that process. So if both parties are unrepresented, they can go to it. Access Pro Bono will give independent legal advice to both parties. But yeah, just a plug in there. Was there more?
There are, I would suggest that you look at Mediate BC.
Yeah.
And look at the search by keyword sliding scale or low income, because there are mediators who are good quality mediators who do in fact offer a sliding scale rate or a lower rate for modest to low income litigants. I'm not allowed to advertise individual people, but if you have specific questions, I can tell you off the side of my desk.
Yeah, I'm not allowed to advertise either, but I do have some people on my list. There's one last question because we are over time. One over here, up here.
Hi. I hope you can hear me through the mask. Anyways, I'm just wondering, thinking about the violence that we've mentioned, and also the cost of everything from mediation to arbitration, are from a client-centered perspective, and keeping in mind that the people that finally come forward have experienced all this trauma, are there instances and ways in which a lawyer or could actually, instead of making the client go through mediation when it's clearly not appropriate and likely to traumatize the person, are there ways in which the lawyer can actually address that or that concern to the court instead of forcing the client to go through that process and incur that expense?
Yeah, Maggie has an answer.
As you may or may not know, you can only force somebody to mediate with you in Supreme Court proceedings. You don't have that ability in provincial court. So the authority for doing that is the notice to mediate regulation. And if you read through that regulation, not only is there a method by which to force somebody to mediate with you, there's also language that allows you to apply to the court for an order that mediation is not appropriate in the circumstances. So it's a very short regulation. It's maybe 5 pages. So it'll be really easy to find if you do need to make one of those applications, an application, notice of application to the Supreme Court, but under the notice to mediate regulation. So you're citing the provision from the notice to mediate regulation. Okay.
So in provincial court, the judge can't force you to go into mediation, even though they can try. But there is a thing called the Family Settlement Conference that you will be forced to go to if the judge orders the Family Settlement Conference. Do you have something to add about provincial court, Maggie?
I misspoke. You can get an order from a judge to force you to mediate. I just meant that there's a mechanism by which one party can force you to the other person to do it without having to go to court to get the order. But anyways,
yeah,
neither here nor there.
Yeah. So in provincial court, like the judge can make an order even though they're not supposed to. And I think for the party who doesn't want to go to mediation because of family violence, they do need to tell the court, like, this isn't appropriate because XYZ. Do you have an answer? Come take the microphone.
So, mediation is actually something that happens before anybody's allowed to go to court in provincial court right now, right? And
In certain registries.
in certain registries, which will be all registries eventually. And so you have to go through the Justice Access Center, and we lose track of our clients when they go over there. So I went over and I obtained their family violence screening tool that they use. And I'm happy to share that. And all that to say, the JAC, who's part of the government, are very alive to family violence issues. They will screen for those things and determine what, if any, type of mediation is appropriate. Shuttle mediations are used very frequently, where the parties are going to be in different rooms and a mediator will be going back and forth. But I've looked at that tool, and it is very, very much alive to the power imbalances. It says, is it appropriate for these people because of the violence and the power imbalances? Like, would it be appropriate for these people? Is there fair bargaining power, essentially? So they're alive to that, and I haven't seen any problems there really at all. But if it was clearly inappropriate, you might apply to have that requirement, that consensual dispute resolution requirement or mediation waived if it's so clear. And I think that information would all go into an affidavit, and then you'd ask to be exempt on that basis. But luckily, the government's up and on it, and their tool is pretty robust. So very happy to send that along, because I had no idea what clients were being asked in those consultations and whether violence was being appropriately screened, but happy to say that it is.
And this is for provincial court. The process that Brittany's talking about is for provincial court family law.
And clients should know that in mediation, nothing happens except by consent. So you could go, and I would tell a client who's really nervous, it's like, but you don't agree to anything until we have a conversation about it. Clients have a right to legal advice. So go ahead and go and whittle it down to whatever you can. But if you're feeling pressured, or if your body's not regulated, and so you're not making good decisions from that place, bring it down, talk to a lawyer, and then maybe go over the finish line.
But that's why it's important for you all to be there, right? Because you're reminding the client, you don't have to say yes. You don't have to say yes. Okay, that's all our time for today. I'm sure I'll see some of you at the afternoon session. Thank you very much for joining us. I'm sorry we went over time.
Thank you.